Yes, good evening to everybody of the aspirants of the JCJ 2022, the main examination. Karibu sana, welcome. And anyone participant can unmute and read that what I posted on the screen. Participant, anyone can unmute and read. Aranusha. Aranusha, are you there? Yes, Gausia, you read. And these two people are there, but they could not read it. But you are hearing me. Kolikonda, are you hearing me?
Yes.
Yes, you read.
I will volunteer to read it. Plea
Read.
bargaining in India. Good morning. Indian Penal Code, Kolikonda Sharath Babu, abatement, sections 107 to 120 of IPC, and Professor Dr. Mohammed Saheb Hussain.
Yes. Let me take the first round. In the plea bargaining in India, there would be an introduction. What is the plea bargaining? And the meaning of the plea bargaining and the history of the plea bargaining in India, CRPC and plea bargaining under section 265 capital A to section 265 capital L. Are the types of the plea bargaining. Number 1, sentence bargaining. Number 2, fact bargaining. Number 3, charge bargaining. Then arguments for the plea bargaining, arguments against the plea bargaining, and case laws and conclusion. Kolikonda Sharath Babu made the abatement section 107, a person abets by, number 1, instigating any person to do a thing, that is called instigation. Number 2, engaging with one or more persons in any conspiracy for doing that thing, within parentheses, that is, say, the conspiracy. And the third, intentionally aids by any act or illegal omission in doing that act, that is called the aid. So today we are the two hosts. Let me take the first turn. Later on I will give to the Kolikonda Sharath Babu. Yes, now let me say that what is meant by plea bargaining. And if you see the section 265 capital A of the CRPC, a sense of confidence in the court is essential to maintain the fabric of orderly liberty for a free people, and if not, they could destroy the confidence and do incalculable damage to society. And the first being that the people come to believe that inefficiency and delay will drain even a just judgment of its value. I don't know. The participant, could you know that what is meant by people come to believe that inefficiency and delay will drain even a just judgment of its value? Can anyone tell me this, what it means? Participants, only two are there, Gausia and Aranusha, but I could not see the Gausia microphone. But I could see the microphone or Anusha, but she...
Justice delayed is justice denied, maybe, sir.
Justice seems to be done. Justice to be done, and it seems to be done. What will happen if the justice is given after 30 years? It doesn't have the value.
Yes, sir.
You feed the hungry man, I say hungry man, Hungry, at the time when he is hungry. Am I right?
Yes, sir.
So, yeah. Kausia, do you want to say anything?
No, sir.
Okay. The above statement written by the Warren E. Burger in an address to the American Bar Association, and this is developed there first, the importance of timely justice in a free society. The timely action is very important factor. Not only that one, even for any activity, time is an essence, and timely action is a very good action. The biggest problem that Indian justice system is facing is the huge backlog of the cases. That is, piling up the cases because it takes a lot of time. What do you mean? Is it only the court will make the delay or any other factors also? Participants,
Other factors may be there, sir.
namely,
Parties to the suit will cause the delay. Advocates may take adjournments because of heavy work.
why they would not be ready on the trial date?
Sir, there may be other matters and work pressure will be there, sir.
So the counsel may take the many cases on that time. He will not be present over there. That way they take the adjournment.
Yes, sir. Sometimes they will take adjournments. Sometimes on conditional orders, the court will grant adjournments.
Okay, noted jurist Nani Palkiwala, of course, is no more now, rightly said, I quote, the law may or may not be an ass, but in India, it is certainly a snail. I don't know how many people, I am quote. How many people know what is meant by snail?
It
Palm,
goes
sir.
at a very slow pace, very, very slow pace.
See, here I have shown you for your understanding. Did you see it?
Yes, sir.
It is called snail means in Telugu, natta. That is the snail. So, according to Nani Palkiwala, what he said, it is like a snail. And more than 3 crores cases are languishing in the courts of various reasons. And of course, this is the old data.
I want to add one more thing also. The number
Please.
of judges is also very meager, very less.
That's why Justice N.V. Ramana, sir, they increased the number of the judges in the high courts also. Not only high courts, in the lower courts also. Am I right?
Yes, sir.
So one of the major reasons behind this is abysmally low disposal of cases by judiciary is the lack of number of judges in the respective courts. Yes, that is also a highly important factor. Apart from huge backlog of cases, the conviction rate in our country is also very low. Hence, the credibility of the judgment is doubted. So, when the conviction rate is very much low, the people will lose the faith in the judiciary. Judicial process is additionally time consuming, cumbersome, and expensive. So these are three factors also.
In many of the cases, the witnesses are becoming hostiles.
Yes, especially in the criminal cases. Okay. All these problems call for an alternative. The best judgment or justice is, I told in my earlier classes. Anyone? Settlement.
There should be,
SETTLEMENT.
that is conciliation, mediation, and
Arbitration.
Yeah, now that's why the Bar Council of India made the ADR should be a compulsory course in the curriculum. Okay, a proposal alternative to this would be bringing in the opportunity of the plea bargaining into the Indian criminal justice system. So with that view, the plea bargaining has existed or come into the picture in the Indian criminal justice system. With this, at least some cases will be disposed early by the pre-bargaining. The pre-bargaining can be as described as, I quote, pre-trial negotiation. I say pre-trial, before the trial. Negotiations between whom? Between the accused and the prosecution, during which the accused agrees to plead guilty in exchange for certain concessions by the prosecution. Of course, the concession will be given the prosecution, and with that, the accused will agree the plea of guilty. They are also referred as a plea agreement, or we can say plea bargaining, or plea agreement, plea deal, or coping a plea. So the procedure for the plea bargaining is simple. Yes. Can anyone unmute and read, which I highlighted?
A bargain or deal is struck between the accused and the prosecution, whereby the accused will agree to plead guilty to the charge when inquired by the trial judge, and in return will get a lesser sentence, or plead guilty to one or more charges in return for the promise that the other charges will be dropped against him. The trial judge takes an active part in this process.
Yes.
So
I
the
told you
accused
now,
is,
concession will be given.
if he pleads guilty,
Suppose if we agree to that one, and the other charges may be dropped. The reason is a concession will be given to the accused for other charges, and the disposal of the cases would be there.
But what would be the punishment?
But can it will be done for the rape cases and the murder cases?
No, there are roughly about 20 cases, something which are defined under the Act.
summary trials cases,
No,
I think.
can I read out? Can I read out?
Yeah.
Prevention of Corruption Act, Prevention of Food and Adulteration Act, Immoral Trafficking Act, Essential Commodities Act, NDPS, Weights and Standards, Customs, Drugs Act, Income Tax Act, Dowry Prohibition Act, Commission of Sati Act, Indecent Representation of Women and Prohibition Act, Immoral Traffic Act, then Fruit Products Act, Meat Products Act, any schedule which is under the Animals Act, SC/STs Prevention Atrocities Act, offences which are under Civil Rights Act, offences listed under 23 to 28 sections of Juvenile Justice Act, Army Act, Air Force Act, Navy Act. These are the explosive acts. These are the acts which are not to be plea of bargaining.
That means there is no plea bargaining in those acts.
In those acts.
If an accused is charged in those acts.
Yes, yes. They are total 28
Please
as
post
on today.
it,
As on today, there are total 28 acts where a plea of bargaining cannot be done. The central government notifies every year.
Gausia, do you want to contribute anything?
Sir, I want to note down. Please post the acts in the WhatsApp.
I'll do it.
Why you want to note down? You could hear.
Okay, sir.
You could hear once or twice or thrice. Or you can Google it also.
Okay, sir.
You make your some efforts. You learn the things.
Okay, sir.
So now what is our Venunath has read it. You could hear it also.
Yes, sir.
Is it not?
Yes, sir.
Yeah, yeah.
Okay. Now, actually in the US, plea bargaining was introduced in the 19th century and has proved to be very successful.
Yeah, it is mostly done in US, Europe countries.
And it has been an integral part of their justice system. Though
Yes,
plea
yes.
bargaining has not specifically been mentioned in their constitution, it is a legality has been upheld in the judicial pronouncement.
Yes, yes, yes.
Today, at most 90 to 95% of the criminal cases in the US are disposed of by plea bargaining rather than the trials.
Yes, yes, yes.
So that is the way we can make it out. That means the trial should be conducted within no time or it should not be lengthy. The reason I told you that justice delayed is,
Justice denied.
and what is the opposite for that one?
Justice hurried is justice buried.
Yes. So now it is the brain of a counsel to take advantage of whether the first one or the second one. Depending upon it, he will argue the case.
Yes, yes.
So procedure for the plea bargaining is the number of ways we can do it. So Law Commission of India advocated the introduction of the plea bargain in India, even though the Supreme Court vehemently opposed it.
Yes.
And it is 142nd report, 154th report, 177th report, the Law Commission of India made such a thing.
Justice V.S. Malamat.
Yeah. Law Commission will interfere in certain cases to see what would be the loopholes in a particular act, or what should be the introduced, or what section should be changed. They will give the recommendations.
Why can't there be a consensus between the Law Commission and Supreme Court of India?
Do you think that even the Citizenship Act is made over there? Do they take the consensus of everybody?
No.
No, because it is pertaining to law, they can come to terms at least to agree on
Sir,
Even
one-
Citizenship
something.
Act also a law. So sometimes they do it because they will take the how many hands are raised in the parliament, they will count it and they will make
But,
it out. Of course, the ruling party definitely they will raise the hand. So the Criminal Law Amendment Act of 2005 introduced the chapter. What is the chapter number? Participants only, not other.
21A, 21A.
Venunad, you are not a participant, you are a host almost.
Arey, sir, I am also student. I am also student.
But you have the wide knowledge. Chapter
In fact,
21.
for that
That
matter,
is
we are all students.
Yeah. So, into the Criminal Procedure Code 1973, this came into effect on 5th July 2006,
6.
the Amendment Act of 2005. So, it allows the plea bargaining to be used in the following circumstances. But let me make one clear thing to you.
Yes.
In India, you will say the Criminal Procedure Code.
Hmm.
But in Tanzania, we will say Criminal Procedure Act.
Okay.
But for Civil Procedure Code, in India, we'll say Civil Procedure Code. In Tanzania, we'll say Civil Procedure Code only, but not Act.
Okay.
I
Only the
sometimes
criminal
I
procedure
get why
code.
it is so.
Mhm.
But anyway, they give their own logic and behind it.
But sir,
Yeah.
for plea of bargaining, there was a circular issued by many high courts
Okay.
informing the accused that he has a right for plea of bargaining.
Okay.
Circulars of High Court's CL number 31/2007, dated 29/8/2007.
Mm-hmm.
There are circulars for many high courts,
Yeah.
and there's also a second circular also.
It is circular by the Supreme Court.
Yes. To use these provisions.
Okay.
But in India, you know how our advocates will do. They will not let the
They
accused.
will not highlight that point.
Yes, because उनका पैसा निकल जाता है ना.
So it is like that. अगर घोड़ा घास से दोस्ती करे,
तो खाएगा क्या?
so you should have to remember the Basanti dialogue.
Yes.
So number one, only for those offenses that are punishment with imprisonment below the 7 years,
Yes.
where the plea bargaining can be. Yes. Now the Sir Venunad also given the list of it. And there, accused, I am sure that they will get the more than 7 years.
Hmm.
So number two, if the accused has been previously convicted for a similar offense by any court, then he,
Or she.
what is the symbol? Only Professor Hussain students make it out.
I didn't understand.
What is the symbol between a he and she?
Gender.
I say symbol or sign.
No, I no idea. I forgot. Maybe.
But I am sure that Kolikanda will give me the answer.
You taught me 20 years back.
Kolikanda, are you present? Virgule. Virgule.
Okay.
I repeat. Virgule. But synonym is oblique slash.
Hmm.
And what is another? Stroke. No, you don't say stroke. Stroke is dog.
Slant,
Slash, I told you already. I asked you
slant.
just now, but you are not present over there. So will not be entitled to the plea bargaining because
Yes.
at the time they are not entitled because already he convicted once.
Yes, yes, yes.
So number 3, plea bargaining is not available to offences which might affect the socio-economic conditions of the country. Like you told me, Narcotic Drugs, Essential Commodities Act, Food Adulteration Act. Am I right?
Yes, yes, yes.
For example, offences under the dowry prohibition also you made it.
Yes. It's against the society.
Under the Commission of the Satya Prevention Act 1987,
Yes.
Juvenile Justice also that you made it. Within
Yes.
parenthesis, Care and Protection of Children Act 2000.
Yes. Age below the 14 years.
Yeah, because in the criminal law they will say 7 to 12 years.
Mm.
But when you take the evidence of a child, what is the test to know the child is having the maturity? There is a test. The judges may make it out. And we discussed it in one of the class last I shown in the on the screen all. Voltaire, what is that? Voltaire, Voltaire. The test
Okay,
will be there. With that, we can say that a child, whether is the maturity give the evidence, is relevant or not.
Mm.
Okay, 4th is, it is also not available if the offense, if committed against a woman or a child below 14 years. Here they made the 14 years.
Yes.
And the 5th one is plea bargaining is not available for serious offenses such as a murder, rape. What are the serious offenses?
Any punishment which is above 7 years. Simple language.
Okay. Waging war against the
Sedition.
If the punishment is more than 7 years,
yeah.
it
Equation is
the equation is very simple. Any punishment which is more than 7 years is not
okay.
entitled for plea of bargaining.
Yes. So plea bargain can happen in the following ways.
Mm.
First bullet, withdrawal of one or more charges against the accused in turn for plea of guilty.
Yeah, for
It's a
plea of
concession,
yes,
bonus,
yes.
incentive.
Mm.
Second bullet.
One thing should be there in plea of bargaining.
Yeah.
It is that it should have more than 2 charges, not 1 charge. If there is 1 charge, there is no plea of bargaining. There should be more than 1.
Yes. Answer is obvious over there.
Uh,
Could you fight alone?
uh,
But in one game, a person can play only one.
Ludo on smartphone.
What is that game?
Even if he plays, he opts for plea bargaining in one case, the sentence may be reduced.
No, not one case, sir. It is very simple.
Yeah.
In plea of bargaining.
But louder, Venunath. Keep your gadget very near to your mouth.
Okay, in plea of bargaining, there should be more than 1 charge, which I mean to say is, example, if there is 302, there should also be 365, something like that. Only 302
Yeah, another
plea of bargaining.
Yeah, we could say charge, but in USA we will say counts.
Yes. In USA say counts, but in India which is the charge.
Charge.
You should have more than 1 charge. Then only plea of bargaining will apply.
He will be 3 counts he made. 3 charges is made against him in charge sheet.
And that person should be above 18 years for plea of bargaining.
Yeah. That is another condition would be there. Of course, reduction of charge from more serious charge to a lesser charge in return of plea of guilty. Yes. Because the instead of Gaussian, you mute it because I am getting the sound from you. So the last bullet is recommendation by prosecutor to sentencing judges for the lesser sentence in lieu of the plea of guilty. Of course, the recommendation with the prosecutor would be there because he accepted the charge, which is high in punishment. For the lesser charge, we can exempt. So it may happen in many cases that the accused entering into the plea bargaining may not do so voluntarily. See, if you voluntarily, if anybody says, then why such a interrogation?
No, I didn't get your point, sir. Can you repeat once again?
See, it may happen in many cases that the accused entering into the plea bargaining may not do so voluntarily.
But the provision says that plea of bargaining should be done by the accused voluntarily.
But but the prosecutor may make some incentives. He will lure him to accept. So some method would be given to him to lure him. But generally when voluntarily will be given, even the concession also be given to him. Therefore, to ensure that the plea bargaining has happened in a proper way and justice has been ensured, the court must adhere to the following minimum requirements. What are the minimum requirements? The first bullet is the hearing must take place in court. Okay. Number two, second bullet, the court must satisfy itself that the accused is voluntarily pleading guilty and there is no existence. That means there would not be any coercion on the accused. Is it?
Yes.
Undue influence? Keeping the revolver at the temple in the zero
What
range?
about convincing?
No, convincing, okay, he can lure it. Because if you accept this charge, then other charges will drop it.
That can be appraised to the accused.
Yeah, because he wants to lure it. So, of coercive bargaining to the prejudice of the accused, I told you just before, there is no coercion. Any court rejecting the plea bargaining application must be kept confidential to prevent prejudice to the accused.
Yes.
So, they keep it...
Closed door. It'll happen in camera.
Okay. Not in open court.
Not in open court.
Because people will suspect.
Yes.
So anyway,
Unless if you're going for a trial, it will be an open court. But if you're voluntarily doing a plea of bargaining, it will be closed door proceedings.
It can be done in the camera. Can it be done in the chamber?
No proceedings can be done in any judge's chamber except for the child. POXO.
Okay.
Except for the POXO. That too on the discretionary of the magistrate.
All right. So in the camera means other people will not be there. Only the accused and the witness and the counsel and the judge.
Yes.
Of course, prosecutor will be present.
The complainant, the prosecution, the accused advocate, and the judge.
Of course, the record man would be there. No trouble.
Yes, obviously. The court staff. The court staff.
The case law under the CRPC, in the case of the Babu versus State of Kerala, the court observed that public prosecutors are ministers of justice, who is duty bound to assist the judge in the administration of justice.
Yes.
Even advocates also, they are the staff of the...
All advocates are officer of court.
Yeah.
This is what it is clearly mentioned in Bombay High Court. Okay. It clearly says all the advocates are officers of the court.
Very good. Even the public prosecutor and the functionary that he will help the judge in doing so.
Yes.
And he can be a catalyst in terminology of the chemistry. So number two, in the case of the V.C. Shukla versus State of Justice Desai, where delivering the conclusive judgment opined, within quotation, the purpose of the framing a charge is to give intimation to the accused of a clear, unambiguous, and precise notice of the nature of the accusation that the accused is called upon to meet the course of a trial. Yes. Of course, it should be very much clearly to be understood to him in the language.
Sir, only public prosecutors are mentioned here. What about the defense lawyers?
I said accused lawyer, I told, no?
Yeah, their view also is taken into consideration?
Yes.
I think he is also an advocate, means he is also a officer of the court.
No, in the first case, only Public prosecutors are ministers of justice who is duty bound
Yes,
to assist the judge
public
in the
officers
administration.
are Minister of Justice because they have been appointed by the state government to assist the
The
court.
judge.
The court.
Yeah, go
But
to the court.
whereas
Respective
an
court.
accused advocate is not appointed by the court or by the state. He
It
is
is the
representing.
discretion of the judge to be present, that he will be present over there.
He is representing the
I
accused.
know it, sir. But what is their role in this plea bargaining?
You should, as a legal man, you know the terms and conditions of law. As an accused or a layman, you don't know what are the language what the court uses. So there should be someone to interpret that such language and what are the consequences for accepting, not accepting. Someone should be there who is confident to that accused. The public prosecutor may not be confident to that accused, or the accused will feel, "Arey, I don't know what he's saying. If I say yes, it will may be harmful. If I say no, it may be it may not be harmful." So the opposite party advocate is always present so as to ascertain that I'm in confident hand. That is why the accused advocate is also present.
Okay. The charge sheet made by the police correlates and meaning the complaint that the private individuals and which the criminal proceedings have been taken place. Submission of the charge sheet by the police officer reflects that the initial investigation and preparing regarding the same case are done, and how magistrate can take offense committed under his consideration as stated in a Ramashankar versus State of AR 1956. So charges, it should be correlate in the complaint of the private individuals. So the charges are framed based on the FIR, also based on the investigation.
Yes, charges are framed on the FIR. How will they frame the charges without FIR?
Okay.
FIR is a must for framing charges.
If suppose in the FIR something is not mentioned, but later on it is found, can you reopen the case?
No, it is like this. If in an FIR certain sections are not added,
Yeah.
let's presume certain sections are not added. So it is later on they come to know he has also done so and so act.
Yeah.
So with the permission of the court, if the offense is related to the same act,
Yeah.
then he can file a second FIR.
Okay.
There's a concept of second FIR, but that offense should be in transaction to the same offenses. But if that such
Suppose the
offense
case is disposed of.
or else, let's presume if there is an FIR is there, an investigation has been done. Police has submitted its report to the court, but the magistrate feels that this investigation is done incomplete, or the judges feel this investigation is not up to the mark. Then the magistrate can order for re-investigation. That is called supplementary investigation.
Okay. When he is not satisfied.
Yes, when the magistrate is not satisfied, he has all the powers. I will not mention the section here, it will take long. He has powers to ask the public police investigating officer to reinvestigate the matter. And only that time only the magistrate will call the accused for the witness, not for the main investigation.
Okay. So now let us see the fourth win. Abhinandan Jha versus Dinesh Mishra. It has been opined that the magistrate is not entitled to order an investigation by a senior police officer in charge of the police station. In this case, the court observed that the creation of the opinion by the police officer by whom or under whom the investigation took place is the final step in the investigation, and the final step is to be taken by the police, not by any other authority.
Yes.
Thus, there is no power expressly or impliedly given under the provision to a magistrate to call upon the police to submit their charge sheet. There is no power expressly or impliedly given under the provision to a magistrate to call upon the police to submit a charge sheet. Means second charge sheet.
Yes.
When the police officer has sent a report under the section 169 and there is no case can be made from the following report to send the accused for trial, In that case, charges are to be made by the magistrate to keep in mind the report submitted by the police as per the section 228 and section 240 of the CRPC investigation. In case, if the investigation, the police made the charges, but the magistrate doesn't have the genuineness in the charges, can he will ask again to frame the charges?
Yes, the court can do, or else the court can suo motu frame charge.
Okay.
The court has all jurisdiction power to do that.
Yeah, these are the cases are there, number 7, 6, but the many cases there, but the time is limited. Kolikanda, could you come to, could you host it, the abatement?
Plea of bargaining and plea of guilty both are different.
Okay.
Plea of bargaining is where you say that, okay, I have done this mistake, I am ready for the punishment. But plea of guilty is different.
Okay.
Pleading of guilty is different. Pleading of plea of bargain is different. Both are different.
Okay. Yes, Kolikanda, over to the Kolikanda.
Okay,
Oh,
sir.
sir.
One more thing.
Yeah, let you make it a later part. Let him finish it.
Okay.
The latter, the time will be left on, then we'll discuss. Yeah.
Okay, sir. No issues.
Chapter 5 of the Indian Penal Code 1860 deals with the offences relating to abatement. Abatement basically means the action of instigating, encouraging, or promoting a person into committing an offense. So it is an action of inciting, provoking, or encouraging or promoting a person into committing an offense. It can also mean aiding the offender while he's committing a crime. So helping the offender while he's committing a crime is also considered as abatement. The term abatement in criminal law indicates that there is a distinction between the person abetting the commission of an offense or abettor. So the one who abets is abettor, and the actual perpetrator of the offense or the principal offense or the principal offender. So there is a clear distinction between the abettor and
Principal
the
offender.
person, the person who commits the act of offense. Abatement under Indian Penal Code. Abatement is considered by number 1, instigating a person to commit an offense, or 2, engaging in a conspiracy to commit it, 3, intentionally aiding a person to commit it. So abatement constitutes all these three things. He can instigate a person, or he can engage in a conspiracy to commit a crime, or he may intentionally aid a person to commit it. The abatement might be instigation, connivance, or collusion, we can say, or purposeful aid as given under section 107 of the Indian Penal Code. However, the words articulated in an angry state or omission without any intention cannot be termed as instigation. Simply uttering angry words may not constitute an instigation. For an individual to be called liable for abatement and so as to proceed against an individual for a criminal offense under section 107, the prosecution must claim the commission of the component of mens rea. So intention. Mens rea means intention of the mind.
Guilty mind.
Negligence.
Guilty mind.
Yeah, guilty mind. Negligence or carelessness cannot be named to be abatement in order to punish the liable according to the arrangement of penal laws. Negligence or carelessness, this cannot be named as abatement. So as to establish abatement, the abater must have appeared to deliberately support the commission of the wrongdoing. Deliberately means intentionally. In such a case, we need to just prove that the wrongdoing charged could not have been done without the association as well as the intervention of the supposed abater isn't sufficient with the prerequisites of section 107. So this should be proved. What should be proved? The abater should
ऑनलाइन
have
क्लास में हुए हैं, बाद में बात कर.
should have supposed to abet the offense clearly according to section 107. Section 108 IPC defines abetter. So abetter means it is very easy that one who abets the offense is abetter, or one who aids or helps another person to commit an offense is
But the
abettor.
principal perpetrator.
Yes, principal perpetrator. In section 109 of the Indian Penal Code, the one who abets an offense is given the same punishment as that of the principal perpetrator of the crime, if the actus reus of the principal offender has occurred as a result of the inducement made by the abettor. So if the crime has taken place because of the inducement made by the abettor, then equal punishment is given for both abettor and principal offender. Section 109 of the Penal Code is applicable in case no separate provision is made for the punishment of such an abatement. Section 110 of the Indian Penal Code gives that even if the individual abetted commits the offense with an intention different than the intention possessed by the main perpetrator of the crime, yet the abettor will be charged with the punishment provided for the offense abetted. So if the intention is also a different one, then the offense committed by the principal or main perpetrator, his intention is different, then also equal punishment is given. He will be charged with the same offense. Section 111 of the Indian Penal Code continues the development on abetment laws around the phrase, each man is deemed to intend the corollary outcomes of his act. Section 112 of the Indian Penal Code expands the guidelines articulated in the previous section. Under it, the abettor is held liable for the offense abetted and also the offense committed. So the abettor is held liable both for the abetting of offense and the commitment of offense. Joint scrutiny of sections 111, 112, and 113 make it richly evident that if an individual abets another in the commission of an offense, and the chief goes further from there on and accomplishes something more which has an alternate outcome from that planned by the abettor and makes the offense an aggravated one, the abettor is liable for the consequences of the acts of his principal. If the offense is an aggravated one, then the intention of then what the abettor intended also, then the abettor is liable for the consequence of the acts of his principal. Case laws. In the case of Tuck versus Robson, a publican, the person who manages a pub or a bar, by not making any effort to make his customers leave the premises after the pub was closed, was said to have aided the crime of abatement of consumption of the liquor after the hours in which it was permitted. Sanjo alias Sanjay Singh versus State of.
Give a bit of explanation for this one.
So here, the person who manages a pub is the bar owner. If he not takes any effort to make his customers leave the premises after the pub timings, then he is said to have aided the crime of abatement of consumption of the liquor. If anyone commits the crime after taking liquor after the closing of bar, then the hours in which it was permitted, then he will be considered as an abater.
That means a person who is fully intoxicated at that time, the barman wants to see that he will be reached to his house safely.
No, not. He doesn't mean to say that. He means to say that
what here is,
if
sir,
there
if
is a
the
pub,
is
if the pub timing is from 6 to 12 o'clock, let's presume from 6
Okay.
p.m. to 12 o'clock. So it is a duty of the pub owner to evict all the people who are in the pub by 12 o'clock. If any incident happen after 12 o'clock, so the pub owner also is an abettor to that incident.
Yes, sir. That is the
Or it is in that way also. He should not serve the more drink to the person who already drunk in a full.
No. There's no rule as such. Up till the pub hours, he can drink 100 bottles. He can drink 1 bottle. He can drink 1 peg. That is up to the capacity of the individual.
But if
Okay.
the person who took the alcohol or liquor commits offense after the bar hours, then the bar owner is also
Held liable.
held liable and he is the abettor of the crime committed by the alcoholic,
Yes.
the person who has taken that liquor.
Means the barman is a better.
Yes, sir. In
Yes,
this
sir.
case,
Because he has not done his duty properly. The closing hours
he
of
has
the bar
not
was
closed
12 o'clock.
the bar within the hours
He
after
encouraged them to
12
sit up
o'clock.
till 12 o'clock. Yeah.
Okay, now let us see that what other consequences.
Sanju alias Sanjay Singh versus State of Madhya Pradesh. In the case of the apex court quashed the charge sheet for offense under section 306 of IPC to hold that the words uttered in a quarrel or on the spur of movement such as to go and die cannot be taken to be uttered with mens rea. For example, if a quarrel is there, then in the course of that, if he says to go and die, then they cannot be taken. They cannot be taken as uttered in mens rea with the guilty mind.
Then he
could not be
cannot be
charged
called
with
as a better.
abettor. He could not be charged with abettor. He means to say.
Yes. He
Okay,
cannot
next.
be considered as, he cannot be treated as abettor. It is in a fit of anger or emotion because he said those words in a fit of anger or emotion. SS Chino versus Vijay Kumar Mahajan and another. In this case, the Supreme Court made some remarkable observations on law pertaining to abatement of suicide under section 306 of IPC. The court ruled that abatement involves a mental process of instigating a person or intentionally aiding a person in doing of a thing that we have already discussed. Without a positive act on the part of the accused to instigate or aid in committing suicide, conviction cannot be sustained. So, there should be a positive act on the part of abettor to commit suicide. The main person who committed suicide must have been properly incited or instigated by the abettor. Otherwise, he cannot be punished. The abettor cannot be, the so-called person cannot be considered as abettor, and there cannot be any conviction on him. There has to be a clear mens rea to commit the offense. So, guilty mind should be there. It also required an active act or direct act which led the deceased to commit suicide, seeing no option, and that act must have been intended to push the deceased into such a position that he committed suicide. So, abatement of suicide must be clearly established. So, there should be direct active act or direct act on the part of the abettor, which has led to the deceased to commit suicide. Otherwise, he cannot be punished. Madan Mohan Singh versus State of Gujarat and another. In this case, it was opined that in order to bring out an offense under section 306 of IPC,
Class में हम बाद में बात करें.
specific abatement as contemplated by section 107 IPC on the part of the accused with an intent to bring about the suicide of the person concerned as a result of that abatement is required. Gurbachan Singh versus State of Punjab. In this recent case, the apex court observed that the basic ingredients of section 306 of IPC are suicidal death and the abatement thereof. So there are two basic ingredients of section 306 of IPC. One is suicidal death and the other one is abatement. To constitute abatement, the intention and involvement of the accused to aid or instigate the commission of suicide is imperative, means that it's compulsory. any severance or absence of any of these constraints would militate against this indictment. So these are the case laws pertaining to the abatement. Conclusion: abatement as a provision has been sufficient both from the view of the offense as well as the penalty for the offenders of abatement. However, with the development of technology and looking at the current scenario, the legislation of India has tried to bring the required changes in this provision through the Information Technology Amendment Act 2008. So after this act, the section has been amended so as to give a wider meaning to the act and omission by the use of encryption or any electronic method. Therefore, we can say that abatement as an offense is just and fair law that enhances the principles of natural justice in the legal system.
Yeah, that is the end of the Kolikonda Sharad Babu's today's abatement topic. And now the 5 minutes are left over there. Vinod, you want to say, you can say.
I'll say only 4 people are here in the class.
Even one also there doesn't matter.
Okay. It is always the plea of bargaining always ends with conviction. Person has to be convicted. He cannot be acquitted under the plea of bargaining. Can a plea of bargaining be done during investigation? No. Plea of bargaining can be done during the trial stage or before the trial stage.
Means after the charges are framed?
Yes. Plea of bargaining cannot be done even during the charge sheet or on the police report time. As I told, there is a difference between plea of bargaining, plea of guilty. Both are two different. In plea of guilt, what happens if an accused says that he pleads guilty? It
In the
doesn't
beginning.
mean, yeah.
In the beginning.
Yes. No, I'm saying plea of bargaining is different and plea of
Yes,
guilty is
suppose before, after the FIR is made over there, then he said, I am guilty to that. He
no. That has
confessed.
no. That has to go to the court. That he has to say in front of the magistrate, not before the police officer.
So that then is it considered as admission?
Well, and I've not yet completed. So I'll come to that. What happens in plea of guilty is that if an accused says that I plead guilty, it does not mean that he or she is confessing to that act. Okay, he or she is not confessing that he has committed that crime, which means that he will not participate in any trial, neither any evidence. Means to let the court take its own decision. I will not participate in the trial. I will not come as a witness. I will not come give my evidence. That is called plea of guilty. Admission is different.
Is it not confession, sir?
No. It is not confession. It does not mean that he is confessing. He is saying, I am not participating in the proceedings. I just plead my guilty. I'm not saying I have done it, I have not done it. Since the charges
Actually,
against
in the
me,
criminal,
it is no. It is a court. Then the responsibility will be on the court to prove him that he is guilty.
yes,
The
because
prosecution.
the burden lies on the prosecution.
Yes, he will not prove that he say I plead guilty, which doesn't
One
mean
cannot be
he is
witness
confessing.
against oneself.
Yes. It doesn't mean that he's confessing to the crime. He says, I'm pleading guilty. I will not participate in any trial, neither any evidence. Matlab, I will just my name is there. You said I'm guilty of this. I plead guilty. Now let the prosecution prove that I'm guilty or not. It means he's not confessing to the crime.
At the time, can the prosecution give any concession?
No. There's no concession in plea of guilty.
Why should he say that? What is the use of it?
Huh?
I am
It's
not
like this.
guilty. Everyone says that I am not.
One minute. Once a person says that his plea of guilty, his burden of proof is reduced from his end. Now the onus of proof shifts to the prosecution side. There's a difference between burden of proof and onus of proof. The burden of proof shifts. The burden of proof will shift to the
Prosecution
side. Now the prosecution has to prove it now, whether this person is really guilty or not.
Okay, go ahead.
In plea of guilty, can a person challenge that order? Then the other important thing is that most of the people we talk about plea of guilty, can that plea of guilty judgment be challenged in the court by anyone, by the prosecution or by the accused? Yeah.
No, because
he
it
has
is a
admitted.
fundamental. No,
Mm.
because it is a fundamental right.
Yeah. One man coming to that. Any
Quick,
judgment,
quick.
any
Time is
judgment
going to
delivered.
up.
Sir, let me complete. You are talking in between.
I will
Any
not stop it. Go.
Any judgment delivered by the court under 265G shall be final and no appeal shall lie except under the special leave petition under Article 136 and a writ petition under Article 226 and 227 of the Constitution shall lie in any court against such judgment. Understood?
Repeat it, sir.
What is the difference between confession and plea of guilt, sir?
Madam, you again what Hussain Saheb said. You'll go through that video since we don't have much time. I'll read the judgment. I'll read the what is whether appeal can be made in case of plea of guilt, in plea of bargaining.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Jai Hind.